T-shirts. So, Rob, there's a couple of things that we've talked about, you and I, and I think it's a really good part of the show that was something we could talk about that we haven't really talked about, and clients always ask this question. They want to know when they're going through the litigation process, are there parts of the litigation process that can cause trouble for their case? And one of the areas that we find, I know you and I have talked about this, that's problematical is when either a client is going to go to a deposition, and a deposition, we've talked about it on the show, is where the defendants have a chance to question our client with regard to how the accident happened and their injuries, and we have a chance to question the defendant about how the accident happened. And there are things that certainly can go wrong, and we like to take the time. I know you and I like to take time and go over it with our clients in preparing that. So let's talk about depositions. And so why don't you kind of talk about what a deposition is, what the purpose is of it, how we prepare our clients, and let's then start talking about things that could go wrong.
Okay. So a deposition is authorized under New York State civil practice law and rules, and what it allows a party to do, most simply, is to depose or examine under oath a person, a party, or in some cases a witness to an accident. And the purpose of the deposition is to lock in the version of the facts that's going to support a person's position going through that litigation. So once you go through that deposition process and you've given your testimony, if the case goes to trial or you have to submit an affidavit in connection with an application or a motion that's being made in that case, you don't have an opportunity to basically change your testimony. It's locking it in, your version of the facts, and you're stuck with, by and large, you're stuck with the testimony that you provide. So one of the things that I always tell my clients is every case is different. And so as we're preparing you for your deposition, so that's the place where the defendant's attorney gets a chance to question you about what happened in the accident, about your injuries, that there are certain rules they need to follow. And some of the rules that we tell them, Rob, we tell them you have to listen to the question and not start to talk before you hear the question. We have that problem with clients sometimes. Right? That's the most important rule for a client. You have to listen to the question. And as attorneys, we want our client only responding to the question that they were asked.
And when we say listen to the question, you know, it's really hard for us. Most of us have a tendency to anticipate. So we anticipate the question that's going to be asked. And in regular conversation, we could do that, right? So what we do is we sort of shortcut everything when we're having a conversation between someone you know. But the difference is when it's a deposition, you need to have the full question and a full answer because the devil is in the details. So if I'm asked a question like as follows, let's say the person wanted to ask a question about an eclipse, and they started to ask, and they said, well, all right, it's sunny out, right, usually most of the time, and you answer immediately, oh, yes, it is, okay, or sometimes it isn't. But the real question they want to get to was, it's sunny out most of the time, but was it on that day, was there an eclipse? So you answered a question you thought it was, but you really didn't answer the question that had to be answered. So Correct. That's, you know, it's kind of a silly example, but I think it really gets to it where what we're trying to accomplish, folks, is we want to make sure that the facts, as on your case, get presented clearly, that you have an opportunity to get those out on the record. And if you're not listening to the question fully and you're not giving their lawyer a chance to ask that question, then what'll happen is either it won't come across clearly, it'll come across incorrectly, or somewhere in between.
Correct.
And, you know, one of the things that I try to tell clients, Rob, and I know, Rob, you do it too, is I say to the clients, look, do it this way. When the person is asking you a question, don't move your lips until their lips move.
It's great advice.
Right? I mean, literally don't move your lips. I had one client, and I said to the client, I finally said, look, this is a stop sign. And I literally said to him, I'm going to put a stop sign up in front of you because they just kept on jumping on it. And what was happening was they weren't getting the information out that needed to get out. So I finally literally drew a stop sign and I put it up literally in front of the client. And, it's not for us. We're not, look, we understand how we normally talk when we're talking to people, and we do anticipate. It's not the time to do it. So that's a really good piece of information, that you have to allow the lawyer who's questioning you to answer or ask the full question. We also have the problem where people will answer the question, but not thoroughly enough, right? We have that problem sometimes.
That can be a major problem.
So
yes.
tell the listeners what could be the problem with that. In other words, someone asks a question and now they're not given all the information that you need.
Okay, well, in taking it to personal injury practice, common, and I don't do the depositions for the personal injury actions, but I've handled a number of motions. I've handled a number of appeals on personal injury actions, and one of the biggest things that I see is a personal injury plaintiff being asked about how the accident or their injuries have affected their ability to do things that they could do prior to the accident. And it's amazing how frequently that question seems to surprise plaintiffs, and they don't give a complete response. They give limited responses, and I think that's something that basically they should be prepared to answer. And for somebody with a serious injury, there's probably a ton of things that they can't do as they used to do before the accident.
That's a really good point. And so we've talked to the listeners on this program about the necessity for the lawyer, when they're doing the case, to take the time, prepare you for your deposition.